Welcome viewers. Myself Basumatary. I teach political science in Bijni College under Guwahati University. Today I am making this video for those students who are studying political science in their undergraduate course under different universities. And I hope it will help the students for understanding the basic ideas about the institution of High Court in Indian states. So in today's discussion, I will highlight some of the main points of the judicial systems in the state high courts of India. Basically, I'll speak on the background of the institution of the High Court in India, and then I'll speak on the provision of the High Court in the Constitution of India, and I'll speak on the composition of the High Courts. Then I'll speak on the appointment of the judges, and then I'll speak on the qualifications of the judges, and then salaries and allowances of the judges and their terms, and the system of transfer of the judges from one high court to the other high court. So basically I'll focus these points in today's discussion. So regarding the background of the institution of the High Court in Indian states, it can be traced back in the British Indian government. The British Indian government, for the first time, they created 3 state high courts in 1862. Those were set up at the city of Calcutta, Bombay, Madras, and then in 1866 another high court was created by the British Indian government that was created at the city of Allahabad. And after 1950s we are having so many new state high courts in different states. Regarding the creation of the high courts in Indian states, the Constitution of India, it provides some provisions, and after 1950, what happens in 1956, another amendment was moved by the British Indian Parliament, and finally they legislated act in regard of the provisions of high courts in 1956, and this act, 1956 act, it authorized the parliament to create the joint high court for 2 or more states. So at present we have 25 high courts in Indian states, and out of them 3 are joint high courts, and those 3 joint high courts are Bombay High Courts, and then Calcutta High Courts, and then Guwahati High Courts. So the jurisdiction of the Bombay High Court as a joint high court, it covers the administration of the Maharashtra and the Goa, then the Union Territories, Dadar and Nagar Haveli, and then Daman and Diu. And the Calcutta High Court, it covers its jurisdictions over the area of the state of West Bengal and then Andaman Nicobar Islands. And the High Court of Guwahati, it covers the state of Assam, then the state of Arunachal Pradesh, and then the state of Mizoram, and then the state of Nagaland. So from this emergence of the modern institutions of high courts in Indian states, we learned that the modern institution of high court, it was not there before the coming of Britishers. Only after the coming of Britishers we have these modern institutions in the judicial administrations, and basically it started with the state high courts. So what happened before the coming of Britishers in the field of judicial administrations? The judicial administration was administered by the kings with the help of the mullah or the pandits, and basically the judicial administration, it was based on the religious laws. So let's see the provisions of High Court in the Indian constitutions, and the Article 214 to 231 of the Indian constitutions, basically in the part 4 of the Indian constitution, it deals with the establishment of the high court and the joint high courts, and it also deals with the organization structure of the high court, and then independence of the high courts, its status, and then the jurisdiction of the high courts and its power and functions. So now we'll try to understand the composition of the state high courts. Regarding the composition of state high courts, the constitutions provide that every high court consists of the chief justice and such judges. The constitution does not specify the strength of the judges, what should be the exact number of the judges. It is not fixed by the constitutions, and in this case the president has the discretionary power. He can decide the strength of the judges in the high courts, and he decides on the basis upon the workload of the court. So regarding the appointment of the judges, the Constitution of India, it empowers the President of India to appoint all the judges of the High Courts, including the Chief Justice and the other judges. And in case of appointing the Chief Justice of High Court, the President of India, he consults the Chief Justice of the Supreme Court of India, and he also consults the Governor of concerned states. And in case of appointing the judges, the President of India, he consults the Chief Justice of the concerned High Courts, and in case of appointing the Chief Justice of the Joint High Courts, the President of India, he consults the Governor of the concerned states. And along with that, the President also can appoint the acting Chief Justice of High Courts when the post of the Chief Justice is vacant or temporarily absent or unable to perform a duty by a sitting Chief Justice of a particular High Court. And the President also appoints additional judges for a period of 2 years. So this provision is there in the Constitution of India regarding the appointment of a Chief Justice and the judges of the High Court. So let's know about the qualifications needed to be a judge in the High Court. The Constitution of India, it prescribes the qualifications to be a judge in the High Court. The first and foremost qualifications to be a judge in the High Court is that he or she should be the citizen of India. Then second one is that he or she should hold a judicial office in the territory of India for a period of 10 years. This is the second qualifications to be judge of the High Courts. And third one is that he or she should have been an advocate of High Courts for a period of 10 years. So these three qualifications are prescribed in the Constitution of India to be a judge of the High Courts. And interestingly, the Constitution of India, it is silent about the provision for appointment of distinguished juries as like the Supreme Court of India, and the Constitution has not prescribed the minimum age for the appointment. So now let's learn about the salary and other allowances of the judges of High Courts. Since 2018, the salary of the Chief Justice of High Court, it has been increased from 90,000 to 2.50 lakhs per month. So now the Chief Justice of India, they draw salary 2.50 lakhs per month. And the other judges, it has been increased from 80,000 to 2.25 lakhs. So now the other judges of the High Court, they draw salary of 2.25 lakh per month. And along with the salary, they also enjoy the other allowances. They are provided with free accommodations and other facilities like the medical, car and telephone. So our question is that why the judges of the High Court, they are paid a handsome salary? This is the question. So they are paid a handsome salary to avoid the corruptions and to have the unbiased judgment. So now I'll talk about the term of the judges. The Constitution of India has not prescribed the term of the judges, but it prescribes 4 provisions. First is that the judge hold office until the attainment of 62 years. That means that every judge of the High Court, they retired at the age of 62 years. And second is that the judge can resign his office by writing to the President of India. And the third one is that he vacates his office when he is appointed as a judge in the Supreme Courts. And fourth one is that the judges are removed by the President on the recommendation of the Parliament. And the ground of removal is that if he is proved to be a misbehavior or incapacity, in that cases, the judge can be removed from the office by the President of India. So let's talk about the transfer of the judges. The Constitution of India, it empowers the President of India. The President of India can transfer any judges of the High Court from High Court to other High Courts, and this case was discussed various times in the Supreme Court, the issue of transfer. And in various times and in various periods, the Supreme Court of India pronounced regarding the issue of transfer of the judges, and now the Supreme Court of India it strongly pronounced that the mode of transfer of the judges from High Court to other High Court, it should not be based on the way of punishment, but it should be based on the public interest. And this was done by the Supreme Court of India to maintain the independence of the judicial system in Indian government structure. In today's discussions, we have learned about the background of the judicial institutions in India and the provision of the high courts in the Constitution of India, and we also learn about the composition of the high courts and their appointment systems and qualifications of the judges, and we also learn about the present salary of the judges and their other allowances, and we also learn the terms of the judges, and we also learn about the transfer system of the judges. And finally, I would like to thank all the viewers for watching this video, and I hope it will definitely help you in learning the Indian political systems, especially the Indian judicial systems. So, thank you.